Hello, my name is Matthew Sears from CGS 3095, and my presentation will be on employee monitoring and privacy at the workplace. In this presentation, I will discuss technology's role in employee monitoring, the ways that employers use technology to monitor their employees, and discuss is it ethical or is it better just for the security reasons. One of the most interesting yet controversial areas concerning public personnel is using technology to violate employee privacy. What limits are there to employers' intrusions into and control over employees' behaviors and personal properties? When is monitoring employees acceptable, and at what point does it become unethical? Privacy in the workplace is a very huge issue, especially now since technology in the picture. We know that employers have, monitored employees since the beginning of time. Henry Ford was very famous for monitoring his employees, but now the technology in the picture, it makes it so much more easier, and it makes the issue so much more relevant. Technology is omnipresent in the workplace. In recent years, the use of technological tools and equipment by companies has grown exponentially. Various types of electronic equipment, which were previously reserved for military or scientific facilities, such as computers, smartphones, CCTV cameras, GPS systems, or biometric devices, are now commonly used by many private companies and are easy and cheap to install. There is no doubt that technology provides companies with new opportunities for improving work performance and increasing security on their premises. That's the main reason you see such a big spurt of technology, is for security reasons. But at the same time, employees' personal data are more regularly collected, and potential threats to their privacy are more commonplace. In some circumstances, the use of advanced technology can pose high security threats, which outweigh the benefits the technology does provide. Nowadays, the role that technology plays in the workplace is that it allows employees to monitor many aspects of their employees' workplace activities. While employees may feel that such monitoring is a violation of their privacy rights, many types of this monitoring are allowed under the law. There are some circumstances where rights are given, but, the law is the law. A majority of employers monitor employees. They are motivated by concern over litigation and the increasing role that the electronic evidence plays in lawsuits and government agency investigations. Employers more so use technology to provide insight into employee behavior based on a trail. This trail is also given a term as digital footprints, and this are footprints that are used to follow you for the everyday workplace. The technology in the workplace usually pieces together all of these electronic records to provide behavior and work patterns that employers use to utilize and evaluate employee performance and conduct. Almost everything you do in your office can be monitored. Such monitoring is usually unregulated. Therefore, unless company policy specifically states otherwise, even if this is not assured, your employer may listen, watch, and read most of their workplace communications. So just assume that you're being watched. So in these next couple slides, I'm now going to discuss the ways that employers use technology to employ their monitors and if they're legal or not. Your employer may listen to your phone calls at work. Employers monitor calls with clients or customers for reasons of quality control, and they have that right. The only time the employer may not monitor a call is under the case of Watkins versus Ellen Berry, is if the employer realizes that the call is personal, they must immediately stop monitoring. But at the same time, the employer does have the right to obtain records of each and every phone call. So if the call is made on the company time, whether it's out of state, they can monitor, but if they realize that it's personal, they have to stop listening. Now, as far as software goes, as far as smartphones go, most employers do have keyloggers already installed, the mobile management devices that will track your mobile messages, the calls, your web browsing history, and your text messages. Now, if you did bring your phone and it is a BYOD, or bring your own device, the situation becomes a little more tricky. Well, it is your device, so as long as it's your device, then they have no rights. But if you put that device in the BYOD agreement and you allow the employer to install mobile device management systems such as keyloggers or a mobile spy, then you give them the right to monitor that mobile device. That's why when you have a phone, you should bring your device at your own risk. Because once you go into that BYOD agreement, you allow the employer to view pictures, emails, messaging histories, lock the device, and access the device at will. Email monitoring. Your work email is not private. If the email system is used at a company, the employer owns it and is allowed to review its contents. There have been many cases where that have been taken to court, whether it be Smith versus Pillsbury or Falmouth Firefighters Union versus the town of Falmouth. And in most cases, the employer wins these cases. That's because once you use the company's servers to send the emails, it technically is their property and their rights. Even if it says it's private or encrypted, once you do it from that company terminal, they have all rights to view your emails. Even if you sign into a personal account, the fact that it's sent over their servers, you're still giving them the right. So as far as emails go, it's really slippery slope. There's really no way of protecting the email because it's sent out on their terminals and their servers. So if you do want privacy in emails, I suggest sending any personal emails outside of the workplace. GPS tracking, or known as global position systems, devices to track employees and usually employer-owned vehicles. Well, think about it like this. If you do have an employer-owned vehicle or any company equipment, they legally have the right to track that because that is their personal property and they need it for everyday use in their company. But at the same time, if you are no longer driving that company vehicle or you clocked out and no longer have or in use of that company equipment, they do not have the right to track you anymore, track your whereabouts. That is the line where it becomes unethical. So I feel like this issue is pretty obvious. If you have what belongs to them, they do have the right to track you because it belongs to them. But if you are no longer in possession of company property, whether it be vehicles, equipment, phones, computers, then they legally have no right to still track what you're doing in their whereabouts. Audio and video monitoring. Now, this is one of the most traditional ways that employers and corporations have been tracking their employees is through good old-fashioned surveillance cameras. However, with technology and modern software, it has helped turn these devices into sophisticated analytic machines. So it's not just about figuring who's been stealing lunches from the company fridge anymore. It's about charting movement that feeds into the larger picture of the company productivity. Currently, federal law does not prevent video monitoring, even when the employee does not or consent to being monitored. Now, there are situations where employers cannot use video cameras. Of course, in your rights of the electronic monitoring and workplace common law federal statutory protection, employers may not secretly record employees in such places as hidden cameras in the bathroom or locker room or common areas, such as the break room. And also, the cameras can't be used if it's used for surveillance and eavesdropping. There are federal laws. It does not prohibit audio recording of phone conversations as long as the party consents to the recording. And the video cameras cannot be hidden. So if it's like behind a wall or something like that, and there's a camera on the other side and the employer's on the other side, that violates employee rights. Now onto the biggest problem, which I think has been on the rise in the most recent years: social media monitoring. Now, when it comes to social media monitoring, this is where it becomes more depending on what state you live in. It all depends on the policies your employer has in place in your state law. Many companies have social media policies that limit what you can and not post social network sites, especially if it's about the employer. There's a website out there called Compliance Building, and it has a database of most social media policies for hundreds of companies. You should ask your supervisor human resources department what the policy is for your company. Now, for most social media, even when you apply, they usually ask if you have a Facebook, Twitter, LinkedIn. That's usually how they find you. But they look at this to see what kind of person they're getting. Now, I wouldn't recommend using your social media at the workplace because from there they can track your social media and see what you're talking about. And they do have a right to add you as a friend, use bots and stuff like that to add you. The only thing that they do not have the right to do, it depends on the state, is request your username and login to actually see your social media. Now, for that much, you would have to look into the state and see where you live and see if that law abides to you. But for the most part, it doesn't in most states. In conclusion, I feel like you need to look at this from both sides of the spectrum. Yes, employees need their rights of privacy respected, but at the same time, employers are faced with the challenge of finding a way to use technology without falling foul of privacy laws. When considering whether to implement a particular technology in the workplace, companies should take appropriate measures to ensure that those technologies are implemented in accordance with acceptable privacy and labor laws. To me, the biggest thing is communication. I feel like the best step and the good practice was to be to carry out a privacy impact assessment that will allow the company to identify any potential threats to employees and the risk of the company breaching privacy and labor laws, but at all times using the gains we have in technology to make the company more secure and use technology the right way. So to end this presentation, I'll leave you with a question. Are technology in the workplace and privacy incompatible. Thank you for your time. Have a good day.